Hi folks, and welcome back to Conveyancing. This is the video for week 1, and in week 1 we will cover contracts and we'll look at the REIQ standard contracts. We will also have a look at the basics. Remember last week I said that the logical place to start for a unit like this is the solicitor's duties. So we look at what our authority is in a conveyancing matter, our duties and some ethics as well. So without further ado, let's jump into the Prezi. So here we are at the Prezi. I thought this little graphic was a good one for this week because it kind of symbolises in a way the nature of ethics and how much they motivate what we do and how we act in a certain conveyancing matter. And often that stuff will be floating around underneath the surface. It really motivates a lot of what goes on above the surface, and it's not really until things go wrong that we realize that we need to have all that stuff underneath the surface squared away and working well for us to have a good result at the end. So without further ado, let's have a wee look at probably the most fundamental component of the unit, which is the contract. So before we can logically talk about our ethical duties, we need to know what our ethical duties will be kind of revolving around. And obviously this will be the contract between the parties and our relationship to the parties to the contract. So this is our kind of number one starting point. Previously, as your text says, open contracts were used in the olden days. That's where we basically just had the absolute bare minimum to get by in terms of the statute of frauds. So parties, price, property. As long as you had those three, the contract was sufficiently certain, then the rules of law and equity would kind of supply the rest. That gradually gave way with increasing urban development and prosperity to the habit of doing drafting up written terms between the parties. Usually they would be drafted for the convenience of the seller, and as you can imagine, the sellers often overreached in what they were trying to get out of the contract terms, sometimes operating fairly inequitably upon the buyer. So that's where the courts of equity would step in to either refuse performance or bring in doctrines like material misdescription that were designed to achieve some element of fairness for the buyer in a transaction. Generally then the printed form gave rise to standard conditions of sale, and this is where we find ourselves now with the REIQ standard terms and conditions. So the first thing I want to say about the REIQ standard terms is they are your new best friend. For the purposes of this unit, you must know them like the back of your hand, and you will need to know them now, you will need to know them when you're in practice. So you might as well get used to them now. It's generally expected that the standard terms are the ones that are going to be used for pretty much all transactions in Queensland. If you're not using the REIQ form, then there's got to be some pretty good reason why. If it's not a standard term, it will be an open contract, the old style contract, like we talked about previously, where you've got parties, property, price and sufficient other terms, written terms and conditions to allow that contract to stand or fall on its own terms. Often where that kind of contract, open contract, is used nowadays, it's more rather by bad luck than good management. So for example, where the parties have been exchanging emails and then all of a sudden they're at that point where they're in a contractual relationship, that's often the way that these kinds of open contracts get concluded nowadays. So the take-home message is really to use the standard terms and conditions wherever possible as your default contract, and if you do so, you will have the benefit of, as I say on the slide there, considerable body of case law that's grown up around the standard terms and conditions that can help you out in terms of interpreting what the clauses mean and how they'll be enforced. However, as the text is also emphatic on, you must realise that contracts for houses and land are treated fairly specially because the nature of each contract is so unique. Every piece of land is different, every house is different, as you'll know, and for that reason, you'll often find case law almost seeming to go like in diametrically opposite directions. And part of that, part of the reason for that is because each case is so unique to its own particular circumstances. So while we do have the benefit of a substantial body of case law around this stuff, you need to appreciate that each case will turn on its own unique facts. So that is the REIQ standard terms and conditions. Please do look them up on Moodle and perhaps download, print them, learn them by rote, no, but do get to know them because they will be of immense use for you in this unit. In terms of the supporting materials that can assist a practitioner with working with the standard terms and conditions, the conveyancing protocols. Now, these conveyancing protocols were coordinated by LAWS12059, and LAWS12059 in Queensland is the big professional indemnity insurer, and if you're a Queensland practitioner, you'll get to know them fairly well. Well, I hope not. I hope you just pay your premiums. And what the conveyancing protocols do is they give you a lot of guidance around what is considered to be best practice in this area. If you have a concern about something, go and hit the protocol first. You'll find there's a general protocol, and then there are a number of different sub-protocols in terms of conveyancing. There's a protocol for acting for a buyer. There's a protocol for acting for a seller of residential real estate, and they're based on that standard form contract that I was just talking about, the REIQ contract. These conveyancing protocols are also available on the Moodle website, so I would strongly recommend that you go and have a look at those protocols. You'll remember back to the introductory video that I did for you, and I did the mind maps of the steps in the conveyancing process and where our knowledge in this unit plugs in to assist us and where it becomes crucial at each step of the conveyancing process. That mind map, those mind maps were compiled on the basis of, as I say in the slide here, the College of Law material and that big buyer-seller table that's in the College of Law material that you will get your hands on when you do your practical legal training. But what the conveyancing protocols are, they're not just a table of steps that you need to do in the conveyancing process. They take you through everything in detail and they explain it all for you in a way that's really helpful, very plain English. And I would certainly recommend that you consult the protocols, the relevant protocol to your particular transaction, pretty much each time you do it, certainly while you're new to conveyancing. And you know that if this stuff has been organised by a professional indemnity insurer, there will be a very good reason for its existence. There will be very good reason why it's coming to being. And obviously conveyancing is one of those areas where there could have been, and there was previously, a lot of backyard cowboys operating, and unfortunately they get themselves into problems, and the professional indemnity insurer is the one that has to wear the payout. So what they've done in order to lift the general standards of practice, get us up to best practice, is to implement these handy dandy protocols. Now, it's a bit of a carrot and a stick arrangement here with the protocols, if you will, because not only are they very helpful, and so there's an incentive to use them to get you, performing at best practice standards, but there is also some fairly heavy sticks that they can beat you with as well. If you fail to comply with the conveyancing protocols, you could pay up to double the amount of deductibles that the professional indemnity insurer will take out of any claim that you make. You may well face increased premiums, increased excesses, and possible penalties, and perhaps even more scary than that, the penalties can not just be monetary. You can also be facing some misconduct implications if you fail to comply with the standards that are set up in these protocols. So do go and have a look through them. You won't be tested on them or anything like that, so don't worry about that, but they are something that you should definitely be very aware of and looking at, just to get an idea of what they're all about and how they can help you when you're confronting the practice of doing conveyancing in the real world after this unit. So that's all I really wanted to say about the contracts. And now we get to the good stuff. So in terms of your authority, what authority exactly do you have when you are acting in a conveyancing matter? So far as the contract is concerned, the first port of call is for you to look at clauses 10.4 sub 2 and 10.4 sub 7. So 10.4, 2 and 7 are reproduced there for you on the slide. Notices under the contract or notices required to be given by law may be given and received by the party's solicitor. That's fine. That's kind of expected, isn't it? Here's the interesting one. Notices or other written communications by a party solicitor, varying the inspection date, finance date, settlement date, will be treated as given with that party's authority. Okay, so this means that you as a solicitor, wherever you notify the other party's solicitor or the other party themselves of your client's instructions on a particular point, and this is the one that crops up often, say for example an extension of the date by which they need to get finance, and that the extension is given, that is going to be treated as given with your client's authority. So it's deemed to have your client's authority. So you need to make absolutely sure that you're only acting on the basis of instructions, and preferably written instructions. Okay, whenever you're going to make a communication to the other side, it has to be done very carefully, because you will be binding your client to whatever you're going to convey to the other party. Okay, now clauses 10.42 and 7 apply, as you'll see by their terms there, to written communications. So they don't necessarily apply to telephone discussions, for example. However, if you look at case law around indulgences, and indulgences is just the term of art for, wherever you allow the other party to do something that they wouldn't ordinarily be able to do. So where you extend the time for complying with getting finance, the condition requiring finance, for example. These are the classic kind of situation where people can get themselves into hot water. And you'll remember the case from your contract studies, Legion and Haitley. I mean, classic example there. So you remember that was, again, in relation to sale and purchase of land. There was some finance that was due to be paid on a particular date. There was the purchasers madly running around trying to get the bridging finance by the date. They realised that the bank just wasn't going to be able to get the money in time. So there was that fateful call between the purchaser's solicitor and poor old Miss Williams of McPherson and Kelly at the seller's solicitor's offices. And the purchaser's solicitor said, look, I don't think we can pay the money on the arranged date. However, we can get finance by this date. And the secretary responded with those famous words, I think that'll be all right, but I'll have to get instructions. Unfortunately, the vendors decided to terminate, and then there was that rather interesting estoppel argument that was centred around the telephone conversation with poor old Miss Williams. And as you'll know, they failed in their estoppel claim, and I'll leave you to revise your contract materials to find out why. So the salient lesson from that case is that you will have authority to bind your client and also your secretaries, paralegals and so on, where they have ostensible authority and they're in your offices, they will also more than likely have ostensible authority to bind your client. And not just in written communications, but also telephone communications can get you into a lot of bother. So the same kinds of principle apply to elections. So you'll know that where there's been a default or some other issue that's arisen and your client has an election available to them, perhaps to terminate or not terminate. In those cases, sometimes you'll be the first person to have the knowledge that would equip you with the fact that your client actually has an election to make and they need to choose the course that they will follow. That is a very precarious situation to be in, because acting with that knowledge, if you communicate anything to the other side that indicates that your client is going to follow one path or the other, there is every possibility, every likelihood that your client will be bound by, for example, conduct by yourself or people with a sensible authority, again, that show that your client will choose one of the paths open to them. So very important, as I said, always act on the basis of instructions, preferably written, and be enormously careful of how you interact with the other side in all of your transactions in conveyancing. Okay folks, well we're over the 15-minute mark now, so I'll stop this video here and I'll carry on with a part 2 of the week 1 video. I'll see you in the next video.